want to talk to you about the America Invents Act, which is the law that was passed in 2011 and which was implemented gradually to change radically the patent system that we had in the US for years. The major change that this law brought, and which was implemented in March 16 of this year, 2013, is that under the new law, the first to file for a patent, the first to file a patent application will have priority in getting a patent for that particular invention, even though that particular applicant may not have invented first that invention. Under the old system, whoever invented first, even though it filed later, was entitled to get a patent. It had priority in getting a patent. Under the new system, again, whoever files first is first in line in getting that patent. And in most situations, that person will actually get a patent. So this law changes substantially how inventors should strategize when they attempt to obtain a patent in US, being a design or a utility patent or other type of patents. Under this new law, an inventor could also disclose the invention publicly before actually filing it to establish priority. Now, if that is a good strategy or not, it depends on many factors and should be carefully considered. For example, let's say you invent something and you disclose your invention publicly to obtain and to rely on that disclosure as your priority date, and somebody else discloses the same invention a few months later but with some modifications, and then you go ahead and file for a patent after that person discloses the invention as well with the modifications. Now that disclosure can be used against you by the examiner potentially to block you from obtaining a patent down the line. So disclosing your invention publicly before you actually file for a patent, relying on what was called under the old system and is called under the new system, the 1-year grace period, which allows you to disclose your invention and even sell it or offer it for sale and go to actually file for a patent later, but not later than a year, of course. Under this strategy, again, because somebody else could in the meantime disclose your invention or a modification of that invention or file for one, this strategy may not work anymore. So what's the best strategy under the new law? It will depend from inventor to inventor, from each situation to each situation, but probably most of the time it's a good idea to keep your invention confidential, keep it secret, and rush to the office as soon as you are ready to file, before you make any disclosure, before you offer it for sale, before you do anything. That's probably in most situations a good strategy to pursue, and that will also ensure that you preserve foreign patent rights, which are lost if you disclose your invention publicly before you actually file for a patent. So keeping it secret and then file probably is the best strategy to go. Thank you for watching.